Great. So let's start, everyone. Yeah. Good evening to all participants, respective panelists, moderator, and members of the ADR community. On behalf of IIDRC, it is my pleasure to welcome you to today's webinar on ADR in tech and startup conflicts, founder agreements, SaaS disputes, and digital contracts. Before proceeding further, I would like to briefly introduce IIDRC. IIDRC functions as a neutral institution providing structured arbitration and mediation services. It has its academic and training wing IIDRC Edge, which conducts workshops, courses, and webinars. We have launched ADR Across Industries Knowledge Series, and today marks the third session of this series. The series aims to foster meaningful dialogue, share practical insights, and promote thought leadership in emerging areas of dispute resolution. Today's topic is particularly timely. The startup and technology ecosystem today thrives on speed, innovation, and collaboration. New ideas are being transformed into businesses almost overnight. Founders are partnering across borders, and companies are increasingly relying on digital contracts and SaaS platforms to run their operations. In such a dynamic environment, alternative dispute resolution, particularly arbitration and mediation, plays a critical role. We are honored to have with us an exceptional panel of distinguished speakers and practitioners who have a wealth of knowledge and bring deep experience and expertise in technology arbitration. It is my pleasure to introduce our moderator for today's session, Mr. Fahimuddin Ahmad Khan. Fahim A. Khan is an advocate practicing before the Supreme Court of India and the founder of Syndicate Law Offices, bringing over 8 years of experience in high-stakes litigation, institutional advisory, and alternate dispute resolution. He has represented clients in complex matters ranging from constitutional writs to commercial arbitrations. As the Chief Legal Officer at the Institutional and Industrial Dispute Resolution Center, he is actively working towards building one of India's progressive ADR institutions, developing systems that combine procedural rigor with flexibility to support businesses, startups, and professionals through structured arbitration, mediation, and online dispute resolution mechanisms with the aim of delivering efficient, neutral, and enforceable dispute resolution beyond traditional court processes. Without further ado, I now invite our moderator, Mr. Fahimuddin Ahmad Khan, to take the session forward. Thank you, and I wish everyone an insightful and engaging webinar.
Thank you very much, Vedika, for the introduction. And hello, everyone, and welcome to the session of the ADR Across Industries series. I would like to just give you a brief of today's session. So the startup ecosystem today is evolving at an unprecedented pace. With innovation, rapid scaling, and complex technological collaboration come equally complex legal relationships. Founder arrangements, SaaS baits, more business models, platform partnerships, and digital contract have become the backbone of modern startups. However, when disagreements arise, traditional dispute resolution mechanisms are often too slow and rigid for the technology sector. This is where ADR becomes extremely significant. Arbitration, mediation, and other ADR mechanisms offer startups a way to resolve disputes in a manner that is efficient, confidential, and commercially pragmatic, qualities that are critical for businesses operating in competitive and innovation-driven environments. Today's discussion will focus on some of the most pressing areas where disputes arises in the tech ecosystem. Founder agreements, for instance, are often drafted at the earliest and most optimistic stages of a startup's journey, yet they become crucial when differences regarding control, equity, or strategic directions emerge. Similarly, SaaS disputes bring unique challenges involving licensing terms, service levels, intellectual property rights, and cross-border transaction. And with that, increasing reliance on digital contract, questions surrounding enforceability, jurisdiction, and dispute resolution clauses have taken on new dimensions. Our objective today is to explore how ADR can effectively address these evolving challenges and how founders, lawyers, dispute resolution professionals can structure agreement and dispute mechanism to minimize disruption while preserving business.
I think there's some glitch with the audio.
Possibly one of the digital disputes and the SaaS disputes we are considering to talk about.
Quite a practical demo.
So I think Vedika, we could probably just take this time to introduce ourselves. I think that will also be in the interest of the panel. So
Yes, certainly. I was just getting connected with him as to what the
yes.
issue is. Yeah.
So in the interim, should we do that?
Yes, certainly.
Okay, so I mean we can start with Dr. Abhimanyu if
Sure. So are we doing our own introductions? Okay, great. Hi. Oh, our moderator is back.
Hi, I think I had a
A
technical
SaaS
glitch.
dispute.
Yes. I suppose that I have to raise this with the Zoom. Yeah, so I'm going to introduce my speakers and I request my speakers, I'm going to give a brief introduction of my speakers. Then there's going to be an opening and then we are going to open this panel discussion. So firstly, I would like to invite and introduce Mr. Arjun Prakash, the director at Mundi, where he leads the enterprise business and strategic partnership across global markets. He works closely with institutional government and leading law firm on high value, long cycle engagements. Some of them include the Indian government, top Indian and international law firms. Mundi is a global legal technology company from Paris, France, transforming international law and arbitration through AI-powered research and data intelligence. The platform provides access to the biggest database of international law and arbitration materials in the world, helping legal professionals make faster, more informed decisions. We are truly honored to have Mr. Prakash with us today, and we look forward to his valuable insights. Mr. Prakash, may I request you to begin with your opening remarks? Thank you.
Yes. Thank you, Fahim. Thank you, Vedika and IIDRC for having me and arranging this webinar as well. Excellent topic, I should say, and very highly relevant. ADR in tech and um, startup conflicts, founder agreements, and SaaS disputes, and digital contracts. So my perspective would be, I think, like might be slightly different because like it would be based on my experience with Usmundi, which, as you shared, is the biggest database in the world for arbitration, covering all key tribunals. It's because like I'm moreover one big disclaimer. I'm not a legal professional, but at Usmundi we support about 1,000 arbitration teams worldwide. So day in, day out, my job revolves around meeting and discussing with our clients or leading law firms, arbitration practitioners. So my understanding on especially this topic is like all the changes that we've been seeing in the world over the past few years, mainly in tech, has led to multiple scenarios, quite different from the past with respect to disputes or in the arbitration space. If I can share more on like what are the differences, let's say for example, if there are like two co-founders, like one wants to exit, one doesn't, and the company is quite new, let's say 3 years old, and they're in pre-IPO. It's like no clean path forward. Like what next? Those kind of disputes, or in for example, if it's a SaaS company and a customer stops paying and claims that the product never worked as promised. The customer is in a different country. There is no clear jurisdiction in this contract. And or for example, if a startup is built and part of its product is on a smart contract, now there is a bug, money is stuck or something like that. Nobody agrees on who's responsible. Multiple parties getting involved here. These are some of the kind of disputes that we've been seeing on Jusmundi's database because since it has a repository of all kind of cases, over the past few years we've been seeing more of this kind. And the question here is like, what's the best way to resolve them? With at least my conversation with professionals, I understand that the preferred choice, even that they say is ADR. But when the discussion goes furthermore deeper, that's when it gets interesting. Just like ADR has always been attractive for tech and startup disputes, there are multiple reasons for that. One, of course, the obvious reason, which is it's faster than the court. And other reasons could be like it is more confidential in nature. That way, it's like protecting the source code, trade secrets, and so on. And the best part is like when it is tech, when it is international, then arbitration awards are enforceable internationally. That also comes handy. If everything is good in ADR for the tech, then why this topic now and why I felt this to be very relevant now is because the point is that like things are changing, especially recently, a lot has got changed. So what's changing is the nature of tech disputes has changed. It has evolved. While the disputes has got changed, it has evolved. I would say like the ADR is trying to keep up. That's the gap that that I find interesting, and that's the reason why I said like the topic is super interesting and relevant today. For instance, even among the examples that I shared today, for example, if it is a founder dispute, if it is from non-tech industry, it's not as interesting as it is today. But since the topic is on tech industry, it becomes very interesting because if it is non-tech, the process is quite simple, like and standard. There is equity, vesting, IP ownership. But with tech, now you got disputes over who owns the algorithm, who gets credit for, let's say there is an AI model, who gets credit for the AI model, what happens to the data when the company splits. Like standard arbitration clauses drafted few years back, that in most cases weren't built for something specific like this one, which wherein like the industry has changed. And if it is, let's say, SaaS disputes, it is also interesting because the contracts, like they're often click through agreements, the service levels are buried under technical annexes. When something goes wrong somewhere, let's say a data breach or something like that, the dispute often turns on like whether the customer even understood what they were signing. Arbitration handles this well, but only if the clause was drafted properly. That's where I'm coming to, which is like it is the most important one that makes this topic even more interesting. And then there are also smart contracts, as shared earlier. This is where things get interesting. You can now have disputes where the contract gets executed automatically It's because there are like money saved, time saved, and so on. But then, like, if the access is like revoked, then both sides starts arguing about whether that execution was valid, which got automatically executed. And the problem is like you in these kind of technical industry, you cannot unrun a blockchain transaction. Once it is run, it is run. So in situation like this, like what does ADR even look like in this context is where like it gets interesting. But all is not done because like, and it's not the end, because things are changing and changing fast as well. For example, some of the institutions are actually bringing and building around this one. JAMS, for example, now it has built specific rules for AI disputes alone. Singapore International Arbitration Center has introduced blockchain focused protocols. And there are also decentralized arbitration platforms that's also coming up. And there are like real good developments that are happening within the institutional space as well. But the reality is like, let's be clear, which is more practitioners are still like using generic ADR clauses that weren't designed specifically for this purpose. So the big question, like as to like what should practitioners do and what should be the way forward, is like, for example, it is to treat the dispute clause as a product decision, not just merely as a legal formality. And then like another thing that I noted is to treat the dispute resolution clause as one that I said about as a product decision, not as a legal formality. The other one is to match the rules to the disputes. If your client is in AI or let's say blockchain, you'll have to look at specific rules, like how I said, one with JAMS or let's say Singapore International Arbitration Center, or it can also be sector specific. And the third one that I thought could be interesting here is about neutrality. So one of ADR's biggest advantages in tech dispute is that you can appoint someone who actually knows the technology, and a technically literate arbitrator who knows what's a, for example, an API or like how a token functions, will be able to run a better process and reach better outcomes. For instance, I can share this, especially since I'm from Yusmundi. This is also fast catching up. And as an example, we have a directory yellow book types with the highest number of arbitration practitioners listed. And the trend that we see is that like every month there are like about 50,000 plus hits, 50,000 plus searches that are going on. And why is it so? It's because people are looking for specific arbitrator, be it in the tech industry or let's say AI specific, or even for example crypto or blockchain. And that is how many people are looking for just to find the most relevant arbitrator to contact them and to appoint them. So that's my introductory mark, and I look forward to this webinar and to hear the expert views from the other panel members as well. Thank you, Fahim.
Uh, Thank you, Arjun, for your opening remarks. I think that was quite, we got a perspective from a business point of view, like what you seeing a lot of other arbitration matters coming through on your platform. A lot of we go through a lot of awards, and some of the points that you've raised are really relevant. And I think one of the ways where we can resolve this issue is expert that has been answered to a lot of other arbitrations as well. So with that, I would like to move on to our next distinguished speaker who will further enrich today's discussion. So Dr. Abhimanyu Chopra, he is the partner in the litigation and dispute team at AZB and Partners. He has over 15 plus years of experience in handling civil, commercial, and criminal disputes, domestic and international arbitration, insolvency and bankruptcy, IPR, telecom, gaming, and competition law. He also holds a double PhD specializing in cyber and constitutional law. Abhimanyu is a certified arbitrator and mediator and is empaneled as an arbitrator and mediator with IIDRC. Beyond his legal practice, Dr. Chopra has authored two books and over 60 published articles in various niche areas of law. He is also the creator of the official app for the Delhi High Court and its mediation center. With that, Dr. Chopra, I invite you to offer your opening remarks.
Hi, thank you for having me. It's a wonderful panel and a wonderful topic, very close to my heart. Uh, you know what? I'll take cue from what Arjun said and how arbitrations and these EDR mechanisms started working in the tech space. We need to figure out why that is, because now when we talk about founder agreements, SaaS disputes, and digital contracts, these are a niche area which requires immediate and urgent attentions, because startups move fast, the capital around them moves fast, product iterate fast, but the disputes around them do not. And when we look at a fundamental mismatch, it is precisely why alternate dispute resolution has become very critical to the technology and startup ecosystem. When we look at disputes in these areas, they don't slow things down, they can destroy value overnight. Imagine a new AI startup which has gotten a funding yesterday and it's gone blown up today. We've seen that with ChatGPT, Gemini Studio, which increased in this entire setup overnight, and they got hit with a cease and desist. That kind of hampers the growth of a AI or a tech industry. So when we talk about, say, founder disputes, for example, we have a lot of startups, and I'll give you examples in India on a daily basis where the startup says, please, we are best friends. We've been working on this startup since college. We don't have any issues. There is no air between us. Whatever we'll do, we'll be constantly doing together. And suddenly somebody gets investment and the fight begins. And these fights are obviously going to happen because as soon as money is involved, friendship, personal relationships, every thing takes a backseat. Now, when many startups begin with this trust and very little paperwork, which I never recommend, what will happen is you will have equity splits over coffee. The roles will evolve informally, intellectual property is going to be built collaboratively, but then is not documented. And then there'll be one founder who will have the IP controlling. So everything works beautifully until it doesn't. And anybody who's seen the Social Network, the movie of the story behind Facebook, you should know that documentations are always key. Anybody can have a dispute on any point of time, and if it is not documented properly, then you cannot enforce it. So when founders call out, the dispute is not just legal, it becomes personal, financial, reputation, and extension for the company. And the traditional litigation around it also takes years. By the time a judgment particularly comes, the company often no longer exists. And we see this, in India very often. But when we now look at ADR mechanism, and we'll deal with it when we go into the thick of it, with institutions, you still have to look at enforcements in the jurisdiction where the parties are. And I can tell you, if parties are based in India, we will have creative mechanics to kind of stall, depending on which side me and my friends appear for. Whether we have a mechanics or a idea behind a tribunal, we will get the judgment, or the enforcement will not happen, or there will be an enforcement, but the company will not exist, and people keep on running around the person around it. And that's why mediation as well as arbitration is not just the dispute resolution tool, they are value preservation tools, because this can, I would say, bypass traditional litigation. It can resolve a dispute over a coffee, or it can kind of ensure that the disputes are going to come for years to come. Now, when we look at SaaS-based platforms, you have in today's economy, we don't just use softwares, we use cross-border technology and softwares. I'll give you an example. A Russian sanction in a company which had an Indian subsidiary got triggered overnight. And as a consequence, the Indian subsidiary lost everything. The entire Microsoft portal went down, and these guys couldn't do email, and they were a SaaS-based industry. And then they had to go to the court that I am not entity which should be hit by the US sanction for Russia. I'm an Indian entity. But they said the drop down entity has a relationship, therefore it cannot happen. And we could not do business. Otherwise, my parent company in the US will get sanctioned. So these are the type of technologies that we're dealing with. It's not an Indian based economy anymore. It's a cross-border economy. And therefore, they don't just use software, they run on it. You take a email service provider's access to his corporate emails, the industry cannot do business. We don't have any information or any traditional hard copies. We have to use information which is in the storage and in the system. And try explaining this to a district court or a traditional courtroom which does not have technical expertise. In arbitration, you can choose your experts. You can figure out who the people are, who the institutions are, who are the appointing entity. We just had a case in the Supreme Court where a person has written a handwritten order in today's day and age, despite having computers, but they said it's just better to write it on the hand. So, we are facing a traditional crunch with a technology ecosystem, and we have to work and, grow around it. And lastly, when we talk about digital contracts and something what Arjun talked about, that there are automations involved. Trust me when we say everything is subject to litigation. A minor cannot agree on those documents, and we know people who are on Instagram and have an email who are less than 13. California reduced the price. Yesterday, Karnataka government said that we'll ban children under 16 from using social media. So we are working on a different parameter and different kind of balance. And therefore, it's always key to know your consumer. What business are you offering, where the consumer is, and how and what system works on it. If you ask me, practically any place in India which does arbitration in the system which is under the institution or otherwise, you need to consider the enforcement mechanics very cogently. If you believe that there is going to be an enforcement mechanics, we've recently seen this with the Supreme Court, where the Supreme Court has talked about an ICC arbitration got installed because of a disclosure issue. Then we are looking at a quagmire of things. And those are my opening remarks. I'll let go of my other panelists and then take up the questions when it comes. Thank you.
So, thank you, Dr. Abhimanyu. I think you've shed light on a very in a beautiful manner, where you just said that your mediation and arbitration, they are a value preservation mechanism. Then you said that the traditional disputes, these are traditional disputes, but these disputes are happening in a era where we are dealing with the SaaS agreements and technologically advanced like on platforms. And then again, enforcement mechanism needs to be there. I think that sums up your opening remarks really. So with that, I would now like to move on to our next speaker, Ms. Pallavi Kumar, to take the session forward. Ms. Pallavi Kumar, she's a partner at JSA and has 10 years of experience in dispute resolution and ADR. Pallavi's practice area is commercial litigation with a focus on arbitration. She regularly represents clients from Supreme Court of India, various high courts, the National Company Law Tribunal, and the National Company Law Appellate Tribunal. She has extensive experience in domestic and international arbitration, both ad hoc and institutional arbitration, particularly in sectors such as construction, engineering, technology, real estate, and infrastructure. I now invite Ms. Pallavi Kumar to share your opening remarks. Thank you.
Thanks, Fahim, for the introduction. And good afternoon, everyone. Thank you, IIDRC, for having me here today on this topic. Like everyone said, it's a very interesting topic as technology and the startup ecosystem is continuously growing. So, what's important is when a startup is founded, most of the focus really goes on obviously naturally building the product, raising the funding, getting investors, and entering the market. Very few founders actually think about how disputes will actually be resolved because that's not the mindset that you're going with. But as the ecosystem grows, business relationships become more complex. That is when disputes in this sector are becoming more and more inevitable. In the last few past decade, we've seen a huge growth in the startup ecosystem and digital businesses, not just globally, but also in India. Startups today operate in highly dynamic environments where innovation is moving quickly, teams are becoming smaller, and decisions are often taken at a very rapid pace. While this agility drives growth, it also means that legal structures governing these businesses are often tested very early in their life cycle. Because of this, the nature of the disputes which emerged from the technology space has also evolved. So, unlike traditional commercial disputes that may revolve around contracts, supply contracts, or infrastructure projects, in the technology, the disputes are often around data protection, software licensing, and complex digital contracts. And in many cases, the parties are probably located in different locations and have probably never met each other and interacted physically. So these characteristics make technology disputes very distinct from the traditional commercial disputes. They involve highly technical subject matter, sensitive proprietary information, and fast moving business environments where prolonged litigation can be particularly disruptive. And this is where alternative dispute resolution mechanisms, particularly arbitrations, has become extremely relevant because arbitration offers several advantages that traditional dispute resolution mechanisms don't. It allows parties to select decision makers on their own, It offers confidentiality, which is very important for these kind of businesses. They rely on proprietary technology or sensitive commercial data. So confidentiality is a very important aspect. And equally important is the flexibility of the arbitral process, particularly in disputes that involve cross-border parties, evolving technologies, and complex contractual relationships. At the same time, the startup ecosystem also brings its own dynamics. Technology startups often involve founders, investors, banks, collaborators who are working together in fast moving and highly innovative environments. So when disputes arise in these kind of contexts, it affects not only the immediate parties, but also the investors, the employees, the future trajectory of the entire business. This is why we are increasingly seeing interest in flexible dispute resolution frameworks where mechanisms such as mediation or expert determination and arbitration complement each other depending on the nature of the disputes. So these were my opening remarks, and I look forward to hearing from the fellow panelists. Thank you.
Thank you, Ms. Pallavi, for your remarks. With that, I would now like to invite our next speaker, that is Ms. Ankita Sabharwal. Ankita Sabharwal is a seasoned data privacy and intellectual property attorney and heads the data privacy practice at Chadda and Chadda. She advises businesses on compliance with India's Digital Personal Data Protection Act, as well as global privacy frameworks, including the GDPR. Ankita regularly speaks at national and international forums on data governance, cybersecurity, and emerging technology law. She works closely with multinational corporations, startup, and healthcare institutions to build practical business aligned privacy programs. May I now invite Ms. Ankita to share your opening remarks.
Thank you, Fahim, and thank you for having me here. To begin with, I think my fellow panelists have sort of summed up everything that, I wanted to say, but I'll quickly add a few things which I feel are very personal to my experience in this practice. Couple of years ago, arbitration or ADR clauses were seen more as boilerplate provisions in a contract. Typically nobody cared about them till something happened. That's when you would go back to the contract. Most of the times, some of these contracts we would see, which were like, companies with series A or even series B, they were literally copy pasted because nobody cared about them. But now I think, things have completely changed. How I look at it, in the past few years, I can say I can easily replace the term technology disputes with AI disputes. Because I think AI is the major operating system behind most technologies in today's time. So, we're talking about a time when a model is probably trained in California, deployed in Singapore, hosted in Argentina, and maybe its users are Indians. This is the complex level of multi-jurisdictional disputes we're talking about. So definitely, like, Dr. Abhimanyu also mentioned, I think I totally agree with the fact that startups iterate every 2 weeks. We have one contract like today, and next week, their product would have completely changed. They would have totally pivoted. But traditional dispute mechanisms are painfully, long. So I think in today's time, ADR definitely is one of the most effective ways of handling SaaS disputes when you're working with different, cloud infra providers, vendors, APIs, API integrations. I think enforceability becomes easier without disrupting business. Having said that, my concern is very different. While I want to just go about saying, oh, well, ADR is the new way, I do believe that even the ADR mechanisms are not enough to deal with the complexity of issues we're talking about in today's time. We have to understand AI is like a black box. So when AI disputes come to us, the explainability and justifiability becomes so difficult that your traditional dispute mechanisms fail. We're not just looking at those, usual breaches where an SLA has been breached and you've not been able to keep up with the promised uptime. I think today's disputes are far more complex than this. You have to integrate the responsible AI principles. Your model has to be non-biased, transparent. There is just so much. So I feel that for ADR also to become an effective dispute mechanism to deal with these kind of disputes, AI governance structures have to be incorporated, because we're at a time and age where disputes, I mean, till about 2 years ago, the kind of disputes which I was personally seeing were that, hey, is this the right kind of data that my model, I'm probably training my model on this kind of data, and I've gathered data from these sources. So can you do your due diligence and advise on that? But now the disputes are, well, hey, this is my model, but apart from risk profiling, it can do these 30 other things. So how much of disclosure do I have to do? But these are just unforeseeable things. I'm not sure today that all of this is possible, but maybe 2 years later it will be capable of doing this and much more. So I think disputes are getting more and more complex. And today, more as a speaker, I'm very interested in being an audience, and I want to understand the perspectives of my fellow practitioners in this space, because every day, my daily practice, I'm wrapping my head around the kind of disputes we're seeing. They're far more technical than we ever imagined, and they're far more complex, even from a technology practitioner POV. So yes, I think I'd like to start with this, and then I'm going to probably build on this as we move forward. Thank you.
Thank you, Miss Ankita. That was really enlightening what you said. That you gave us a practical view of what's happening in technology disputes as you were handling the same, and rightly said that we do not know. 2 years is too much of time. I think the age of AI is around 3 years. That baby is 3 years old, and it has achieved a lot. So I'm just amazed by Claude's ability. Chat GPT has now been, outdated. People have stopped using the same, and Claude is the new thing. And I don't know, you're right that, in next 6 months or a year, it might do something that we are not able to imagine right now. So, you said that, you wanted to be an audience in this. However, I will not let that happen and direct the first question to you. So, so my question is that, like, AI systems and algorithmic accountability, so with businesses relying more on automated decision making and AI-driven tools, question around transparency, bias, responsibility, and liability are becoming very more prominent now. And as AI systems are increasingly processing personal data and making autonomous decisions, do you foresee disputes shifting from traditional breach of contract claims to algorithmic accountability claims? So, what's your view, like whether arbitration would be equipped to deal with these kind of issues where, normal breach of contract now, because algorithms are taking these decisions. So, how we are going to see that? Like, what's your opinion?
Again, Fahim, I don't foresee it. I'm already seeing it. These are the kind of disputes which are coming more and more.
Yeah.
Algorithmic accountability, now that's a different ball game altogether with the kind of automated decision making we're looking at, right? See, we have to typically understand that all data has some kind of bias, right? If somebody claims that my data is unbiased, I mean, that itself is a bias, right? Now, what bias suits you is what becomes the question here.
Yeah.
Let's take the example of a big tech. I'm not going to be naming this company, but one of the biggest e-commerce platforms in the world.
Yeah.
Couple of years ago, right, they were left, right, and center rejecting resumes of female employees. two resumes with similar capabilities, almost very similar educational background, and the resume of the male employee would crop up and would be easier to pick up for them. So everybody was rather baffled by what's happening. That's when they realized that the data which the model had trained on was of 1990s, where we did not have many women in STEM, right? So that data itself incurred a bias against women in that practice. So now, when your model is doing this kind of decision making, where your model is responsible for rejecting resumes for your credit scores, I think it goes beyond algorithmic accountability. It is much more than that. It is about the fact that how much you're able to justify the reasoning behind that decision, that comes into the play in this whole situation. And like I said, most of these models are like black boxes. It's once something goes in, it's very difficult to understand the reasoning, the logic behind it. We're all running after the right principles of transferability and accountability and all of that, but I can guarantee that more than 99.5% of AI companies will not be able to guarantee the RAI principles being incorporated into their models. Because it's very difficult to do that. Your model is built on a certain data, which will have its own bias. It will be very difficult to justify the decision making. So now, how do I see the disputes developing in this? They're huge. We've seen that, from a consumer POV, several consumers have had these issues with airlines, and they've reached the courts of law where they've said that their refund was denied because an AI model just believed that it was not right for them to get that refund. So we've already seen these disputes crop up. They're definitely sporadic right now, but the next few years, I see these disputes being the major practice areas for most law firms. Earlier, these were things which were considered to be very niche. But I think in today's time, all lawyers, you can be a civil lawyer, a consumer lawyer, even a criminal lawyer. You're expected to understand a basic level of technology, because these disputes are incorporated into most of our practice areas. But do I believe that is the current mechanism enough to handle it? No. Like Dr. Abhimanyu said, I also believe that, at the moment, how many, technical experts do we have in this space? You It's just so difficult. We're talking about these courts of law which have taken cognizance of more complex IP disputes even recently.
Yes.
So now we're talking about AI disputes. And if we talk about technical experts, it's extremely difficult. So my personal belief would be that for us to govern algorithmic accountability, automated decision making, all of that, we need a very solid structure within our alternate dispute resolution mechanisms. We're definitely looking at some of the European guidelines on AI governance in ADR. That should be a starting point for us. And as these disputes grow, I do believe, okay, one thing that, I would like to flag here, that now my practice, at least, it's less and less of your traditional SaaS breaches, less and less about your vendor contracts. Those are things I think, with Gen AI, most of the companies have already figured out. Now the disputes are that, oh, but this is what I believe that my model could do. Like I said, unforeseeable circumstances. And how much of unforeseeable circumstances can you account to in a contract? That becomes the question of law.
Yeah.
So yeah, honestly, just concluding it, I don't have a clear answer. I do not know how things will go from here. But one thing that I do believe is that it's going to just get more and more challenging. As attorneys, as fellow practitioners, you have to upskill yourself. You have to understand how a model works for you to be able to, advise on it. So that's what I believe. Yeah.
So yeah, thank you for your answer, Ankita. That brings a lot of clarity. I think what clarity that I have got today, and for the audience would like to share that, when we deal with human beings, we deal with different business models. We can actually predict some of the disputes that can happen. But now, as we're dealing with algorithms, we're dealing with AI. We do not even know what it's what's the capability of the AI, what are the possibilities, and what disputes can arise. Like as you rightly said, that it rejects it. The example of a airline, that it rejects the refund because it felt that they're not entitled to the refunds. However, a person would do or deal with the same differently. So that is something that we're dealing with. Thank you for your answer. And now I would like to direct my next question to Mr. Arjun Prakash. Uh, Arjun,
Yes.
yeah. So Arjun, another important dimension in the global rise of technology-related disputes and how arbitration is evolving it to address them. So, as tech business operate across jurisdiction, arbitration is increasingly become the preferred mechanism for resolving complex and cross-border technology disputes, as traditional dispute mechanism have completely failed. So from a global data set, because you're managing the global data set and dispute
Mhm.
patterns, do you see any a trend in technology or startup related disputes that practitioners should be paying attention to, but currently they are not?
Okay. So that's true, Fahim. At Jusmundi, there are roughly about 100,000 plus arbitration cases from all key tribunals. And it's true that there are many emerging trends. But when we talk about emerging trends in the tech and startup disputes, the conversation usually goes to topics like AI contracts, crypto collapses, data ownership fights. I'm not denying it, they are totally real. But today I wanted to highlight on something different. It's not about what the disputes are about, it's about like how they are being fought. For example, in tech dispute, it has become more of a procedural battlegrounds. The fight these days is over how the case runs has become more intense than the fight over the actual merits. In a traditional commercial dispute, be it some other industry, let's say mining or construction, the thing is that like both sides know the playbook, but in tech dispute, you've got source code on one side, they refuse to hand over it, and the confidential algorithms stuck in the discovery request, and the parties running to court and arbitration simultaneously over the same issue. So we've seen these cases where the entire arbitration became a war over who gets access to what. And there have been instances where even some tribunals spend more time managing that dispute than deciding the actual case. Yeah, there are like numerous examples. One case where I remember is the panel literally used words like procedural gamesmanships in their written decisions. So the big question is like, why does this matter? The challenge here is most arbitration clauses in tech contracts. That is one thing that I would like to highlight here, which is like those clauses in tech contracts are still drafted like it's like a few years back, let's say 2020, 2015, or sometime even as back as 2005, something like that, which is like it's super generic, and less thought is given to how discovery works, where the key evidence is this proprietary code of the company in source code. So less thought is given to parallel proceedings, and when the actual moment arrives, you're stuck improvising inside a framework that was never built for any of these things because it was built on a generic one. So I said previously in my introductory note, institutions are catching up fast. And one example that I gave was JAMS. Another example that just struck me is LCAM from London. It has this blockchain arbitration rules with on-chain enforcements as well. So these are genuinely useful tools the thing is that like several practitioners still less aware of these things, and that's why I wanted to highlight this particular trend. Only a few are putting them into the contracts even before a dispute arises. That is what I believe is more important here. From this, my key takeaways are like first is auditing, which is like auditing the arbitration clause right now or at the earliest time possible, it's like especially with respect to discovery and confidentiality. Being vague is like super dangerous when the dispute actually arises in the tech industry. Another one that I wanted to highlight is knowing about the new rules with respect to the institutions and on what dispute it actually is. For example, if it is AI, it's better to go to JAMS, or for example, if it is blockchain, right now LCAM is better. There is ABRAM for cross-border digital cases and so on. And another one is like again, once again, the one that I touched before, which is built in technical expertise early, which is like being technically literate and having a technically literate arbitrator or a counsel. It's no more a luxury in these kind of cases. It becomes more like a necessity. So the procedural choices that one makes, sometimes even years before the dispute starts, can determine the outcome just as much as the law itself. So that's one trend that I wanted to highlight here for him. Yes, thank you.
So, thank you, Arjun. I think that is something that we need to take into consideration, where we have to be technically literate. The arbitrators, the counsels, the parties, they need to be technically literate in order to you know make these dispute, understand this dispute and resolve these disputes. We have to know about the technicalities of how an AI operates and how these disputes might play, because most of the time it takes a lot of time to understand this dispute, and if there is not an expert, he would just be sitting over there and they would just be trying. Most of the time we spend understanding these disputes. So that's a very valid point that you've raised, Arjun. And with that, now I would now like to shift the focus. Like we've discussed about AI, we've discussed about SaaS agreements and technology. Now I would like to shift the focus to the founder disputes, and that is where I my question is now posed to Ms. Pallavi Kumar. So it is often seen that in legal and relational breakdowns, hybrid ADR models combining mediation and arbitration are increasingly being explored to resolve disputes while preserving business relationships. So, so do you believe such disputes would benefit from hybrid dispute resolution models combining mediation, expert determination, and arbitration, rather than relying on a single mechanism?
Yes, absolutely. Hybrid dispute resolution mechanisms are absolutely important because, like we discussed earlier, founder disputes are not like any traditional disputes because startups are actually based more on relationships and trust. And it's when the trust actually breaks down that disputes arise, which is why the traditional dispute resolution, only an arbitration, is not actually enough. And like Dr. Abhimanyu had mentioned, a class example is the Facebook example. So that actually shows how exactly when a company starts becoming successful, how founder disagreements arise, etc., etc. So, and founder disputes are actually very interesting because they rarely arise from any legal interpretation of a contract. And most of these disputes stem from misaligned expectations or out of control, equity, future direction of the company. Sometimes they are, out of, just mere differences in leadership style. That's that. I mean, that's as little as that starts founder disputes. So, because of this, relying on a single dispute resolution mechanism may not always be the best and the most effective approach. And that's why hybrid ADR models, this is where they come into play and they become very useful. For example, mediation at the very outset before arbitration. Mediation can sometimes help founders address the key and the underlying concerns, and they can explore practical business solutions such as restructuring of the roles or negotiating an exit or agreeing to a buyout arrangement. without immediately moving into fully adversarial process. But if the disputes cannot be resolved through mediation, the parties can then move into arbitration, which of course is more binding and enforceable. But of course, like I think all of us have been experiencing as a practitioner, I've also experienced arbitration starts with, we always tell the clients that it's going to be a 1 year process, but then the extensions are granted and it goes on and on. And of course, it's become almost as time consuming as probably litigation. The issue is that it also becomes very costly for the clients. So a lot of them then also enter into settlements in the middle of arbitrations. And then, of course, there are issues relating to enforcement of an award, etc. So also expert determination as a mechanism can be very helpful for where there are some specific technical questions that often arise in these kind of founder disputes. For example, in cases of valuation of shares or vesting schedules or determination of fair market value, their expert determination plays a very important role. So rather than forcing every issue into a single process, hybrid ADR mechanisms will allow different aspects of the disputes to be addressed through the most appropriate forum. So, of course, for these models to work effectively, they also need to be very thoughtfully incorporated into the agreements, the shareholder agreements, and the founder agreements that they enter into at the drafting stage with a clear multi tier dispute resolution clause. So, in my view, such hybrid frameworks can provide both flexibility as well as finality, which is very important in startup ecosystem, where prolonged disputes not just affect founders but also investors, employees, and the entire value of the company.
Thank you, Ms. Pallavi. I think you've correctly stated and you've given an example, as Dr. Abhimanyu has also given an example of Facebook. I think one of the examples that we see how disputes can actually be very fatal, or if you do not resolve it, you won't. I think it's quite fatal for the business for a startup. So if the founders disputes are there, so it might be the end of that business as well if that is not resolved properly. One of the example is the disputes of Zomato founders. I think they resolved quite in a very nice manner, in which the business was also the exiting partner also got something and the business also advanced. So with that, like my next question I would come back to Arjun, and Arjun, like this question is with respect to cross-border digital contracts and jurisdictions. So, in cross-border, often there are complex questions around applicable law, jurisdiction, and enforceability of dispute resolution clauses. As the other speakers have also highlighted that, with this technology, we do see a technology, the source code being in some country, it's being developed in another country and deployed in Y country. So in these digital contracts where party may never physically interact, how should tribunals determine the most appropriate seat of arbitration and governing law? And do jurisdiction clauses in digital contract genuinely create certainty, or do sometimes shift litigation burdens onto weaker parties? What do you?
So, I'm sorry for him. I did not get the last point, last sentence.
My last sentence was
Mhm.
like, when these digital contracts, the jurisdiction is provided over there, do they shift the litigation burden onto the weaker party? How is it?
For him, I believe like this goes in more into the legal context. Probably like I might not be the right person to explain more on the legal concept of this one.
Yes.
Yes,
And
a big, yes,
Dr. Chopra, I think we have not come back to Dr. Chopra.
yes.
Sorry, what's the question now for me?
Yeah. So, Dr. Abhimanyu, so the question is that with cross-border digital contracts, we are seeing that often complex question of law, jurisdiction, and enforceability of dispute resolution clauses are there. So, in these contracts where parties never physically interact, how should tribunals determine the most appropriate seat of arbitration and governing law?
Okay, I'll summarize this by beginning. If there's an Indian party, please ensure you comply with Indian law in one way or the other. Otherwise, you will have such a quagmire of disputes, and I can give you examples upon examples of how these disputes run, not just in and founder disputes, but just in a traditional dispute sense. I'll give you very interesting practical examples I've used in the past, and I'll ask you a question towards the end of it. Who do you think was at fault? But let's just talk about what is the seat of arbitration. Traditional sense, whether you have a physical contract, digital contract, you govern the jurisdiction clause, you govern the location, the venue, the seat, and you believe that yes, we have a good arbitration clause, and if there is a dispute, rudimentary, that is what is there. I'll give you an example with AZB. When we do kind of these drafting of contracts, year upon year, the corporate teams and the disputes team kind of sit together and figure out what is a good institution, what is a good arbitration clause, and what to keep in mind. I'll give you small instances. India came out with the 2015-19 amendments of the Arbitration Act. Now there's a 12.5 issue where earlier you can have appointed a panel of arbitrators. That is gone, thereby meaning that every arbitration which was either being run or employed those contracts have to either gets restarted or substituted by a new arbitrator. Problem number one, change in law. Problem number two, you had institutional clauses where you had institutional model clauses added, but you had an Indian party and you had a foreign party. You got an enforcement, or I would say you got the initiation and the appellate process sorted out. But when you came into enforcement, the company did not exist, or there was a technical quagmire in terms of stamping act that you did not adequately stamp the award, therefore it is unenforceable. I'll give you example for Daiichi. Daiichi is, I think, from a 2016 arbitration enforcement, which is still pending. A foreign arbitral award upheld all the way to the Singapore courts, came into India for enforcement. First got stuck on the issue of minors being involved, which was against the public policy, got set aside on technicality to the limited extent of some part of the HUF, but the commercials continue to run. So you see that even with the good arbitration institution and appellate mechanism, we had problems on stamping, we had problems on public policy. So does the seat of accommodation or in a digital contract or otherwise, I don't think so, should be a criteria for the Indian party. Simpliciter, because I know when you have an Indian party of either side, there will be problems. But yes, if you want to generalize it a bit, let's say if there is a larger contract, something like a Google agreement or Microsoft agreement, which is a click wrap agreement, you click on it, you go through, largely they will work. But I'll give you an example of the same thing that happened. The Russian sanction with Nika, with the entity which was involved. Now they got stopped. An Indian entity hit by a foreign sanction in a jurisdiction where there was no sanction imposed. So they said, okay, we'll figure out, we will give them this idea, we will restore their services till the time we get a notice back from a parent entity. Minimum shift, but they had to do a contractual restructuring to employ an Indian IT company for routing their business. That's how they got over the sanction. But these are such issues that you will not figure out from I would say, a theoretical point of view. You have to have the theory of the model clauses, like Arjun said, it has to be right. It does not have to be ambiguous. But when you have a tribunal, and again, a more ad hoc based or an institution based tribunal, you do have to consider implications when you go to the entity where you're looking at enforcement, which is key. Otherwise, there is no point doing arbitration. You can simply file a civil suit and you may get a better result. Otherwise, you go into enforcement and you don't have a final result so far. Daiichi, as an example, from 2016 to 2026, we are still in enforcement. 10 years. That's insane. In another jurisdiction, you wouldn't have had that issue. We have other institutions where even after expeditious disposals of appeals, you cannot enforce awards. People have started using IBC, for example, as a mechanic. If there is a party who is going into a dispute, and look at the ingenuity of it. There is company A, company B. There is a dispute going on, appointed by SIAC, go to a SIAC appellate, they lose on the arbitration, get an award against them, go into appeal, lose the award. They come into India for enforcement. They have a vendor who files the IBC case against them. Your arbitration is stalled. The
Yeah.
IBC kicks in 238 and Section 14 puts out a moratorium. If you had a money-based award or monetary decree, you now become an operational creditor. So to the extent that if there's a banking or there's another financial creditor involved, because your decree is an operational decree, but if there's a financial creditor, that is what you are looking at. And that financial creditor will have a better right on the money of that particular entity. So your entire arbitration is gotten set aside. Your award is meaningless. You may not even get a penny on a dollar, which you would have gotten a dollar on a dollar. So that's why these entire structures have to figure out how arbitration is going to work. Another recent amendment in the Bombay side of it, Bombay has imposed an ad valorem stamp duty on an arbitral award. Now, MCI is going to have a hard time explaining why to come into jurisdictions like Bombay to do a matter, because if you have to enforce that award, that's going to be a huge chunk of change. Why would people spend that much amount of money? And the logic behind is money to the exchequer. But Bombay does not have an ad valorem fees in a litigation. I would rather do a litigation where there's a cap on court fees, ask 100 billion and still pay 3 lakh rupees. But in this case, if I ask 3 billion, my enforcement amount is going to be exorbitant. So technical realities have to be considered, which is why I say when you are working on a contract, always have a dispute side of it to look at it, to look at the swiftness of how the enforceability is. Jurisdictions where you actually go. Again, I'll give you an example from an Indian standpoint. You come to Delhi, where the High Court has the supervising role in appointments. You file a petition which is completely fine before 12 o'clock, it gets listed the same day. You do the same thing, say, for example, in Allahabad, it'll get listed after 6 months or 6 weeks. That kind of timelines for appointment, only for notice to be issued and people to file a response, is going to delay the proceedings. Again, from a place when we talk about SaaS based agreements, you may have Microsoft, Adobe, different types of softwares. Now, when you have a personal account versus a corporate account, the difference is going to be humongous. If there is an individual A who is just a student who is running a software, it doesn't matter to him whatever he clicks, as long as he's using the service, he doesn't foresee that there is going to be an issue. Take this to be a founder who is now one person who has immediately after funding set up 50 accounts. Those 50 of them will not have the same kind of idea because they are running on the founder's ID and they are going to have subsequent sub IDs under the main IDs. And when there is a dispute or there is a non-payment, the entire business stalls. And in that time, you cannot really foresee and go to a foreign jurisdiction for arbitration because it's going to be costly. So you have to come to your home jurisdiction. If they come up in a defense saying, okay, there is an arbitration clause, it's agreed upon, they don't have a right, you still have to fight it. It's going to be a civil dispute. It's not covered under arbitration because there are extra elements to that arbitration. So Indians, I can say, are very enduring and genuine in making cause of actions in litigations and how to work around that litigations. But yes, these are practical difficulties. And looking at governing laws, now let's say we are in a war-like situation. We had COVID as an example, act of God. Those clauses are practically during that time not enforceable because you are now stuck where you cannot step out of your house. SIAC started an online mechanism, which I also tested for them, which Arjun was saying uses the protocols for blockchain and data privacy. But again, the filing, the system, how it works, it involves people signing a document. In arbitration, while evidences and processes are informal, you still need an affidavit. You still need a notary. Those are practical considerations which have to be looked at. And if you don't do that, then there will be, there will be no acts, no criminal implication, there will be no perjury, and people can pretty much plead a false defense. So you have elements that you have to consider practically, and you have elements that you have to consider theoretically. Theoretically, everything can be hunky-dory, but practically, you can have problems. Another format I can give an example of, you have currency issues. Now, when you are doing a dispute, when people appoint SIAC and there's a tribunal, I have seen cases in India where they say, there is Indian law, we agree to the arbitration clause, but now the clause is becoming expensive. The 3 tribunal members, to set up this entire thing, we are spending a lot of money. We cannot practically now join arbitration. If you don't pay up, then you don't have a right of audience and your defense gets struck off, your counterclaims get struck off. So the Indian court said, okay, fine, we understand there's a possibility. Whosoever will win will win. We will ask the institution to let the 3-member tribunal be discharged and a sole arbitrator be appointed. So had the idea been that time available to them, they should have appointed a sole arbitrator instead of a tribunal. You wouldn't have gotten stuck into this. So there is now an ancillary proceeding going on. That's an additional cost. Your arbitration is stalled. And for the timeline, and in India, this happened in the year 2014. I'll give you an example. I did an arbitration which started prior to the 1996 Act, under the 1940 Act, where the tribunal was established in 1994, continued to give a verdict. It was international commercial arbitrator. Appointment was by the district court, which is impermissible. That went on for 8 years. Nobody appeared. Ex parte award went to US for enforcement. US courts did a action in India regarding the execution formalities. It was defended, saying that this is not maintainable. A 34 could get pending for 15 years, got struck aside, and the arbitration got set aside. In 2017, a fresh petition for arbitration filed in the Supreme Court. And the Supreme Court said, we're not getting into the merits of the matter. Prima facie arbitration, go before the arbitrator. Imagine an arbitration has continued over 30 years. And then also because it was ad hoc, you did not get the revenue. For a person defending an arbitration, is equally important that you're spending that kind of money. And when we talk about again the jurisdiction clauses, do they create certainty? Maybe. I would say theoretically, yes. Practically, you are in a quagmire because wherever you have to do enforcement, you have to go to that jurisdictions. And again, depending upon foreign law in terms of domestic law, in ICC and Paris, you can talk about fraud in an arbitration. We cannot do that in India. There's a public policy issue. You can look about elements where perjuries can be decided by the arbitrable tribunal. In India, it cannot. In case there's an award passed by an arbitral tribunal and the party says, I will not consider it, the arbitral tribunal will have to first consider an application, send it to the court. So, the quagmire of events are so much. And that is why choosing the right institution, choosing the right appropriate appointing jurisdiction is very key. And when we talk about tech in arbitration, we have Singapore, we have London, we have Dubai. But when we talk about these virtual arbitration proceedings, and when you're talking about these institutions, you are eventually going to come to a situation where you have to consider evidence. And if you cannot do evidence properly, where a person is not in front of you, you have these technical repercussions. I'll give you an example. During COVID, we did something very similar where there were guidelines involved, where a person will be on one side of the room, there will be camera pointing to him. They will ensure there is nothing on their ears, so they are not being prepped, because this was happening from their house. We were in the middle of COVID when we had to continue with the arbitration. So even in those times, a person can really well say, I'm having technical difficulties. My laptop is not working. And they just come out of it when they know that they're going to be hit with a question which is going to impact them. So, while you have the solutions, while you will have implications, you do not have everything covered. And that everything not being covered will obviously lead to a vacuum, which will effectively hit your award and effectively hit your arbitration. I'll end with one particular example that I've given, which I promote ADR with. There was a matter during pandemic where a hotel entity agency which was collaborating with a property in Sikkim. They did everything, all agreements. There was an arbitration clause, everything. Agreement for 12 years, stamp duty paid. So stamp duty not being a issue. Grand day of reopening. 40 people enter the premises and they fall flat as soon as they cross the door. Effectively, everybody shows symptoms of being possessed. Effectively, we found out that the claim of the property owner is that, the property was haunted. Yeah. So now we are in COVID, spending an exorbitant amount of money. We have 40 people who have fallen flat. We don't have medical services coming there. And this is the event between the second and the third wave. So now what do? Do you go into arbitration? Who are you going to explain that the property is haunted? So that's where the ADR mechanism comes in. We tried the mediation route. It effectively got settled. But this is a practical situation in India. 2024, the London jurisdiction came out with a verdict of how do you determine a property being possessed. And that case is still ongoing. But this is one example where ADR is the only mechanism. You're not going to tell an arbitrator that yes, the property is haunted. Now, rule on me that this contract cannot be enforceable because of 40 people who have fallen, and are being taken to a priest who is doing the entire event with a Bible around with, and it is not funny. We rarely saw videos. It was a thing. So in that case, can you go into litigation? Can you explain an arbitrary tribunal? This is the reason a possessed uh, you know, victim or tenant of that property.
So, I'm so sorry, Dr. Abhimanyu. We've quickly taken a turn from technological disputes to to paranormal disputes. So absolutely, like, that's India has weird clause systems. We have weird practices like that is there. That is, I completely agree. We've seen the culture of copy paste, uh, where jurisdiction and all these factors are not even considered, because these are taken as boilerplate clauses, as Ankita pointed out. Uh, because this is a very interesting issue, jurisdictional and issue, that how can we choose the jurisdiction in order to minimize the disputes or the friction in our dispute resolution. So just a quick views from request Pallavi Kumar to also give some light on the same. What are your views?
Sorry, what's the question? So sorry.
So I'm just extending what Dr. Abhimanyu has said, the opinion on jurisdictional. How can jurisdictional issues, like deciding the jurisdiction, can reduce the friction in dispute mechanism?
Yeah, so I think the primary focus while deciding while we're talking about the governing law, etc., should be in terms of enforcement, because ultimately that is something that is most relevant to the governing law, the seat, etc., everything. And that's something that we advise, because across different high courts, we have different, as my experience says, that in Delhi High Court, it's the fastest as compared to the other high courts. So I think the driving factor should definitely be in terms of enforcement, which is the fastest, because there's really no point going through the entire process of arbitration, of spending 2 years of hard work, and then ultimately coming back with a paper decree, or coming back with something which takes years again to get it enforced. So yeah.
Yeah. So absolutely. I think one I would like to add on a lighter note that we can parties can go for arbitration with institutions like SIAC or IIDRC as well, just to give in some pointers to that. And I think Arjun, uh, as you've seen, Dr. Abhimanyu has pointed out a lot of different cases. So the AI would also be a little confused if it start taking data from these arbitration, which has taken 30 years to be completed. And I think it's more than even litigation. So a quick announcement for the participants as well. So your questions, if you want, if somebody has any questions, you can put that in the chat. And we'll ask that at the end of the round. So my last question, I would like to come back to Ankita. And the data, when we deal with technological issues, data is become one of the most the data protection law becomes one of the most important questions. So given the rise of regulatory regimes such as India's DPDP Act, along with global framework like GDPR, how should arbitral tribunals address situation where contractual risk allocation clause conflict with mandatory statutory privacy obligations?
Right. Thank you for the question, Fahim. Firstly, I'd just like to say you can't do much. The Digital Personal Data Protection Act and the GDPR, right? These are these are penalty acts. They're not private disputes that we're talking about here. You can have as much of, contractual risk allocation and, do all of that. But we have to understand, okay, I'll give you a very practical example. The DPDP Act, right, it stipulates certain obligations on the data fiduciary, who's also known as the data controller, regarding how the data fiduciary is supposed to manage consent, typical fiduciary obligations. Now, if the data fiduciary tries to act super smart and push those obligations to the data processor, it's not like the, contract will get the data fiduciary out of the situation, because the tribunal will interpret that if the obligations of the data fiduciary are conflicting with that which are stipulated in the statutory framework, then obviously the statutory framework will govern that, right? So under the GDPR and the CCPA, we've seen companies act very smart. They've done that, they've had all those contracts, but enforceability of these contracts from a regulatory point of view is not possible. What is your obligation is your obligation. The DPDP Act, typically, if you look at it, it stipulates zero obligation on a data processor. But of course, when it comes to those mechanisms of having reasonability and all of that, you can push those obligations. But suddenly, if a data fiduciary says that, oh, the entire risk belongs to that of the data processor, it's not possible. So it'll be a good thing that I know for a fact, because we are helping so many companies globally comply with the DPDP. Companies are trying to curate contracts, and we are very happy to do it. To be very honest, you tell me what you want, I will create it for you. Enforceability is your headache later, because we have to understand that arbitration works on party autonomy, right? You can have your risk allocated in whatever way you want to, but that party autonomy cannot conflict with the statutory obligations which are provided under the act. So if clients come to us, we will advise them to a certain level. Well, this is your responsibility, and this is the incident response mechanism you will have to do, the technical logs you will have to maintain. But sometimes they're living in some gibberish land, and they're like, no, no, this should belong to the vendor, please put it. So after a point in time, as a practitioner, you will put it. You tell them, hey, this won't be enforceable. But I think from a practical point of view, do as much as you want, whatever you want. Enforceability will be something we'll see now, in the
In
next
the stage of disputes.
yeah, yeah. Because see, the DPDP Act, the GDPR, the CCPA, the PDP, all of these data protection laws, they are not, they're not compensatory. That, oh, if your data has been breached now as an individual, you will get that compensation. Because then those become private disputes. These are penalty acts. They're for the government's treasury. So be ready for effective regulatory enforcement on that front. There is no decision making which is going to happen through arbitration. You can have arbitration decide SaaS disputes. You can have arbitration decide if a DPA, probably data processing agreement was probably not aligned. But enforcement, arbitration will not decide, the tribunals will decide. And honestly, from a data protectioner's point of view, I'm really looking forward to how the enforcement takes place, because we were a part of the meaty stakeholders committee, and we were involved in the drafting of the act, and how kicked the government was. So I think everybody needs to gear up for effective enforcement now.
Yeah.
Sorry,
So
can I just add one small point to that?
yes,
Yeah.
The
yes, sure,
appellate,
sure.
the appellate mechanism of the DPDP is a decentralized appellate tribunal which will be notified and constructed. But you know what is the funny part after that? It goes to a tribunal called as the TDSAT, which is the appellate mechanism, which is
Yeah.
currently dealing with information technology disputes after the 17 merger, which is right now of 2010 and 2012. The tribunal is overburdened with 5 separate different acts, because the adjudication in this is going to be either we settle. If you want to settle, you pay me 20 crores. If you don't settle, I'll impose a penalty of 250 crores. I will uphold it, and then you fight it at TDSAT. And
Yeah.
that tribunal is, at the breaking point after the merger for the Information Technology Act. So the technicalities and the appellate mechanism and how it will go to the Supreme Court when it reaches the Supreme Court, that is something for everybody to watch out.
And
Yeah.
just adding on to that, to give you a perspective, there has not been a single adjudication under the IT Act till date.
Yes.
No, 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 no.
No, I think there has
There
been
is, there
one,
is,
or yeah.
there
But
are around 72 adjudications. The right word is, most of them are still under appeal. because the
Yeah, so
Supreme Court
like
has
when I'm
not
saying that
decided.
there's not been a single adjudication decision
Yeah,
because
by the
back,
Supreme Court.
yes,
By the
yes,
Supreme. It's there
back
with the
in
tribunal.
yeah, so that's the level of enforcement we were looking at earlier, but now because the DPDP Act is a more specialized act and it gives the government that impetus to enforce it, I think the enforcement's going to be very, very robust.
Yeah, I think CGI, the Honorable CGI just remarked that, making tribunals was one of the biggest mistakes that we did to our judicial systems, because then it's a burden on the judicial system that you have to appoint members. They have their own pendency, and then they're not functioning, and then all the issues come to Supreme Court. So yeah, enforceability becomes an issue. I really hope that we have put a lot of information out there, and it was quite a engaging discussion that we had today. And certainly, I've had a deeper understanding of this issue as a moderator, because as a moderator, I had the privilege of listening to people from different backgrounds, like Dr. Abhimanyu Chopra, Agnita Sabharwal, Pallavi Kumar, Arjun. So I've got really good uh, feedback on this issue. And I think if we have any questions, Vedika, do we have any questions from the audiences? Because I still feel that this is an area where people are still trying to grab hold of those technology.
Right.
So
No, so I don't think, I think everybody
yes.
is quite awestruck with what they've actually heard at the session. It's, ranging from tech to paranormal activities to, I don't know, all the fields have been covered. So I think we'll proceed with the closing remarks for the session.
Okay. Okay, so I would now like to thank all our speakers for those insightful reflections. Uh, and that brings us to the end of this session. Thank you once again to our distinguished panelists for sharing their valuable insights and expertise on ADR in tech and startup conflicts today. Your thoughtful reflection provided our audience with a deeper appreciation of complexities and opportunities in this field. Now, I would now like to hand over to Vedika for the closing remarks. Thank you.
So, before we conclude, I would like to extend our sincere appreciation to our moderator and distinguished panelists for drawing on their vast experience to share such valuable perspectives. Your collective expertise in technology arbitration greatly enriched this session and made it both insightful and impactful. We also thank all our participants for being an active part of today's discussion and for contributing to this knowledge sharing initiative. E-certificates will be provided to all the registered attendees in 2 to 5 working days. And we also look forward to welcoming you for our next session in the AAI ADR Across Industries Knowledge Series to be held on the 4th of April 2026 on ADR in Banking and Finance, Loan Defaults, Guarantees, Insolvency, and FinTech Disputes, which is again another niche and an increasingly relevant field. And in case you have any queries, you may reach out to me. Also, thank you for attending. We've also shared a feedback form in the chat for the participants for the AAI webinar series. Your feedback for this session would be most immensely valuable. So please You can go to the chat box and fill the feedback form for the webinar.
Uh, Vedika, I think I'm done with your closing remarks, but I would just like to thank all the panelists and the attendees, especially the panelists. We had a very engaging discussion today, and we should take it forward. Bank on this, because of the time constraint, I feel that we're not able to uh, discuss much on the issue. Like, we can delve deeper into this issue, and I think come up with some kind of solutions to the problems that we have discussed today. So with that, I would like to thank the panelists. I think I've been enlightened by all of you today. Thank you very much.
Thank you. Pleasure
Thank
being.
Thank you. Thank you so
Thank
much.
you, Fahim. Thank you, Vedika, for arranging
Thank
this.
you. Thank you so much.
Thank you, ma'am. Thank you, ma'am.
All right. Bye.